How do I know if something's patentable? Now, people often get very confused about what's patentable, and they'll say something like, "Hey, that's a great name for a product. You should patent that name." Or they'll say, "Hey, that's a really cool product idea. You should copyright that." And when people say these things, it's because they have a misconception about what a patent protects or what a copyright protects. And often, what it is a mismatch between the type of subject matter that is protected with that type of IP protection and what they actually have. So it's important to have the right subject matter. And on a bigger scale, so a thing to realize is that if you're talking about product ideas, then you're talking about a patent. If you're talking about branding or a logo, the name for a product, that would be a trademark. And if you're talking about content, like the words on a page, a song, a video, the graphic design of your website, then that type of content is protected with a copyright. So products are protected with patents, um, branding is protected with trademarks, and content is protected with copyrights. So it's got to be the right subject matter in that realm. But also, when it comes to patents, there are categories, like subcategories here, of the right subject matter that it has to have to basically fit the mold, to have what's called patentable subject matter. So um, those categories are machine. A machine is something that has working parts that interact with each other. So it might not be moving parts, like it could be an electronic circuit, but it's different components that have some type of functional interaction with each other. That's what's considered a machine. There's something called a manufacturer. A manufacturer is like a single piece item, but it has a function. So a paperclip would be considered a manufacturer. It's a piece of wire, a single piece of wire that's bent in a way that gives it a spring force that holds pages together. So that's the second category, manufacture. Third category is composition of matter. A composition of matter is when you take different chemicals and you put them together, when you take different ingredients and you put them together. So a pharmaceutical or a hair care product, that could be considered a composition of matter. And then the fourth category of patentable subject matter is a process. Now, a process was traditionally things like a new method of refining steel, where the steel itself wasn't different. It was just that you had a new process that was maybe more efficient, a better series of steps for refining steel. So that's the traditional form of what a process is. And more recently, over the last few decades, computer software has been considered a process. It's been patentable as a process, I should say. So computer software, the series of steps that you go through would potentially have patentable subject matter as a process. There are some complications when it comes to software. Over the past several years, the past 6 years, there was something in 2014 called the Alice case. It was a Supreme Court case that kind of limited when software would have patentable subject matter, when something might be considered what they call an abstract idea. And when something was considered an abstract idea, then it's not patentable. So the point is a little bit more complicated considerations when it comes to software. But in general, those are the categories of patentable subject matter: machine, a manufacturer, a composition of matter, and a process. Now, you don't have to know precisely which one it fits into. You might say, well, I mean, my shovel, it's kind of like a machine, but it's also like a manufacturer because it's one piece. It doesn't matter. It has to fit in at least one. You don't have to know precisely what category it is. It just has to fit in at least one of these categories. Okay, so then to know if something's patentable, first of all, it has to have the proper subject matter. It has to have patentable subject matter. But then second, it has to be different enough to be patentable. So I think it's pretty plain to everyone that in order for something to be patented, it has to be different, right? I mean, you don't patent something that's old. You don't even think about patenting something that isn't new, isn't groundbreaking in some way. But then it gets a bit more complicated because we have to figure out if it's different enough to be patentable. Now, under the law, there are two requirements for how different it has to be. The first one is it has to be novel. Now, to be novel, it doesn't take very much. It basically means that it has to be different in some way from things that have been done before. And it's usually pretty easy to uh, to find something that is different in some way from previous things. I mean, it's like if your invention was a pen and it's not but your pen is like specifically 10 inches long, a 10-inch long ballpoint pen, then it's probably going to be different from other things, and that maybe the patent office examiner wouldn't be able to find an example of a pen that's specifically 10 inches long. So then it's novel. But then that's when the second qualification comes in. And um, and that second qualification is that it has to be non-obvious. And what that means is that it has to be outside the range of what people in the field would ordinarily think of. Like, even if no one had done exactly this, would it be obvious to someone in the field? So, if you think about it, to someone who is in the field of ballpoint pens, they know that you can make the ballpoint pen just about any length you want. So, making it specifically 10 inches long fits in the range of what people would know to do, even if they haven't said precisely, make a 10-inch pen. So, the point is, that would be obvious, and therefore that's not different enough to be patentable. So to be patentable, something has to be not only novel, but it has to be non-obvious. Okay, so then now, how do you figure out whether it's new and non-obvious? Well, the first thing you need to know is, well, what are the closest things to it? I mean, you can't decide if it's different enough until you know what you're comparing it to. So that's why it's important to do a prior art search. And prior art are inventions that came before your project that that are of a similar nature, that are relevant to this question about whether your invention is different enough. So we do prior art searching to search for prior art, to search for things that would be relevant. And typically, we do prior art searching in existing patents and existing published patent applications. There's a record of over 10 million existing patents that you could search to see if there's an example of your invention that's too close for you to then patent it. So, that's the step that you want to do in order to make that determination, is to do prior art searching. Okay, I got a follow-up question here that says, can I do my own patent search on the internet? Yes, it is possible to do your own prior art searching on the internet because there are various databases available. The easiest to use is something called Google Patents. Now that's at patents, P-A-T-E-N-T-S .google.com. So Google has a search engine for patents, and it looks familiar. It looks like any other Google search that you do, where you type in a search query, like you might type in can opener with two handles, and up will pop a bunch of results, a bunch of patents that seem to be relatively close. And when you use a tool like this, you will find things that are relevant. But the question is it the most relevant? And so here's the thing, is that when we write patents, when I draft a patent application for a client of mine, I'm free to use my own terminology. We've got this like fancy term in the patent field called being our own lexicographer, which means we could make up words. I could make up a word for that handle. I could call it like a hand grip assembly instead of a handle, or I could call it a actuating lever. So the point is that if you're searching for can openers on Google Patents by using descriptive words, you might not find something that really is the same invention, except they didn't call it a can opener. They called it a container, a container lid remover. And so the type of search that you do online using words is not going to be the most accurate. It's not going to give you the most relevant information. It could be a good way to rule out a project. It could be a way for you to do a little bit of research and realize, hey, there's a lot of things just like it. It's probably not worth doing this. But if you search and you search and you search online, and you do your, essentially you don't find what you're looking for, I still recommend that you have a professional search done before you file a patent application, because it costs a lot more to do the patent application or to have it professionally prepared than it does to have the professional search done. So it just pays to do it. Um, now, I had a follow-up question here, which is, when an attorney says they do a prior art search, would that be enough to do if they don't analyze the prior art search? No, not really. I mean, you want the attorney to review the prior art search. You want them to go through it and be able to explain to you, what the prior art represents and what about yours is potentially different from what other people have done. um, because one of the most essential questions you want to figure out here is not only is it different enough to be patentable, but is the thing that makes yours different, in other words, the thing that you would be able to get a patent on, is that something that's important? If it's possible to get a patent because there's some details about your invention that are different, then it might not be important. It might not be worthwhile to apply for a patent. You might be getting a patent just on the details, and that's not going to prevent someone else from following the same concept. That's not going to give you the leverage to get a licensing deal, because if you presented your idea to a company or someone that might license your idea from you or want to produce it and pay you a royalty, then they'll be excited about the concept, but they'll see that you're not getting a patent for the concept. You're getting a patent for the details. And if those details don't matter, then they'll just do it a different way, and there'll be no need to license the invention from you. So it's very important to have the prior art search reviewed by the attorney, not just finding a pile of patents and handing them to you, but they should give them to you so that you could look at them, and then they should review them also, and then go over with you what appears to be different. So, and another follow-up question about this in terms of when something's patentable, process versus method. Can you distinguish between the more? Written instructions for use of the device would be which one? Okay, so first of all, process and method are basically interchangeable when it comes to patents. So we call the category a process. Uh, and often when we're talking about the claims are the part in the patent application that determine what someone would need to do to infringe. So in the case of a process, it could be laying out those steps. Like, what's the first step? What's the second step? What's the third step? And we call those, often we call those method claims, and sometimes we call them process claims. So it's basically the same thing. And so you said it's written instructions for the use of the device. So a method of use could potentially be patented as a process or as a method. It really is the same thing. Um, Follow-up question here was, what would be the average cost of a prior art search with a review? I don't know what the average is. I mean, I can tell you that my firm, we charge $1,800 for what's called a patent evaluation, which is basically a patent search with the review of the prior art and discussion with you about what your options are. So again, we charge $1,800, and of course that could vary. This is being recorded, so who knows, a year from now it might be more than that, but right now it's $1,800, and I'm sure there are people that charge less, and there are definitely people that charge more. And let's see. Um, Okay, well, I think there's some other questions here, but I think that really tackles it in terms of how to know if something is patentable. If you're joining us for the first time, welcome. We do this every Friday at 12 p.m. Eastern Time, 9 a.m. Pacific. You can click the link in the post to be invited to join us on the Zoom so you could then ask me anything about patents and trademarks.